We have a wonderful staff that's been scurrying around because we needed a bigger room today because we figured that there would be some people here, and we're grateful for your interest in the State Records Committee. Let me just welcome you all today and down here to the process that we're going to go through. Many of you have not been in a meeting like this today. So let me explain a couple of things about our procedure. The State Records Committee is kind of a quasi-judicial committee. So in order to help you understand what that means, I'm going to read this statement. The Utah State Records Committee was established by the legislature to hear appeals and decide disputes concerning access to records. In doing so, we operate like a court. We hold hearings, administer oaths, question the parties, review records privately, have the power to subpoena and compel attendance of witnesses, issue legal orders supported by written findings, and issue fines for non-compliance. Because these duties are we sit as a judicial body. The law requires that a portion of the hearing be conducted in an open this portion. Therefore, to gather information, question the parties, and hear from the witnesses. And we don't do so in an open meeting. However, because deliberations are a judicial function, the law allows us the opportunity, if we choose, to deliberate privately. This allows us to review the evidence and case materials free from any clamor or pressure. We only analyze the questions of fact.
Pretty much guarantee it, but I gotta figure out.
After deliberations are concluded in private, we are to reach our decision openly and publicly. So we may decide at some point to remove ourselves to have a discussion, but we'll come back and summarize whatever discussion. So I want to welcome all parties here today. And let me have the committee introduce themselves. And since most of you don't know what the state records people do, we're appointed by the governor. And so as each person introduces themselves, I'm going to ask them to tell us their name, but also what it is in their background that makes them qualified to be So we'll start down here with Ken Williams.
My name is Kenneth Williams. I am the state archivist.
On your side.
Can't hear you.
Speak up, please.
Two people can't hear you.
My name is Kenneth Williams. I'm the state archivist. I've worked for the State Archive since 1992, and I've been a member of the State Records Committee since 2017.
I'm Natalie. I did 23 years in the military, did records management, also 3 years as the State Records Committee Secretary, and I'm the citizen representative.
And I'm Marie Cornwall. I am a citizens representative. I taught sociology at Brigham Young University for 30 years. I've done a lot of research, and much of that research is involved using data from state records.
My name's Ed Beeler. Law enforcement for 28 years. I'm currently the chief of police in Humboldt. And have some experience in electronic records, which is the division that I represent, with different databases associated with law enforcement.
I'm Linda Peterson. I'm the media representative. I've been a community journalist for more than 30 years. I've also been the president of the Utah Foundation for Government and a member of the Grandma Tax.
Okay, thank you. Now we'd like to have the parties introduce themselves. I understand in addition to a petitioner, we have, an intervening party. So let's, petitioner, would you introduce yourselves? And then the intervening.
My name is Michael Clara. I'm the petitioner, and then this is my witness.
Okay, and your witness name?
Is Kieran Andrews, Kiran.
Okay. And the intervening parties.
I'm Natalie Clawson. We're intervening party.
Bill Lyman, member of the Utah House of Representatives, also here.
Thank you. And the respondent?
I'm Eric Clark, with Washington County, and with me I have, Scott. I'm the county attorney.
Okay. So you're both attorneys. Okay, now, we must swear in the petitioner and the intervening parties if they are not, attorneys. We recognize that when attorneys are, given the right to practice law, they have already sworn, themselves. So we will need to swear in first, Karen Andrews. Yeah, if you could just, you don't need to stand. Yeah. Hold on just a minute. Let me find the language here. Oh, thanks. Do you affirm that you will tell the truth, the whole truth, and nothing but the truth under the penalty of perjury? Thank you. Okay, and then Clawson,
And I am.
you're an attorney. Mr. Lyman?
I'm an attorney.
Okay. Do you affirm that you will tell the truth, the whole truth, and nothing but the truth under the penalty of perjury?
Yes.
Okay, now,
Michael Clark is.
oh, I'm sorry. For some reason, I was assuming you were an attorney. Okay. Mr. Clara, do you affirm that you will tell the truth, the whole truth, and nothing but the truth under the penalty of law?
Yes.
Perjury.
Yes.
Yes, okay. Thank you. All right. I appreciate all these people who are helping make sure that we do this right. Okay. Now, one other statement I have to make is that
Thank you.
communications or mediation, government records ombudsman cannot be used in this appeal hearing or in any administrative hearing provided as testimony or mediation. Now, I need the parties to agree to that. Do you agree to that? You understand? Okay. All right. That's good. All right. So now, because we have an intervening party, we have decided that what we're going to do is we will give the petitioner 5 minutes to introduce, then the intervening party up to 5 minutes to say something. We really limit this opportunity to speak because we have reviewed all of the paperwork that's been submitted, so we're all very familiar. And just keep in mind, we have 8 cases to review today, not just this one. So, and then we'll have 5 minutes from for this one. And after the committee will ask questions of both the petitioner, the intervening party, and the respondent. So if Claire wants to go first.
Can we switch? Can they go first? They just have more of an overview of what we're talking.
We can't allow that by rule. It needs to be a petitioner.
Yeah, and actually you remind me one more thing I really must say. There is we have to follow the Utah State Code regarding records management. We would expect that the arguments made today will be made responding to that code, not to other political issues. The question is, can you provide us with information that will help us decide whether or not these records have been properly classified? Okay. All right, go ahead.
All right. So I have a PowerPoint.
Yeah, I am sending it to people in the back
Okay.
to share because I actually can't fit onto it. Okay.
Let's start now before the timer starts.
Yeah.
All right. So my name is Michael Clara, and this introduction is really a response to if you read what Washington County sent you guys last week. Then I'm kind of responding to that. And so I wanted to point out what my role was in this is that at the Republican convention in April, and some people had asked me, they were interested in getting the Senator Ibsen's signature list and Norton's signature list, who was on the State Board of Education, and they did grammar requests and they were denied. One was to the Lieutenant Governor's office, and then I believe the other one was to Washington County for Ibsen. So I looked at the paperwork and I said, well, let me try to do a grammar request. I was able to get Governor Cox's signature list from the, go ahead and change this slide. And so the governance, so that's how I got involved in this, really just helping. And we were looking at state school board issue first. So this is as you point out, this is the prevailing law that I was looking at that says that the custodian of the records of a signature, that you can get two things from a signature candidate signature is the list, as A says, and B, the image of it, which I believe the interveners are more interested in the B, and I'm more interested in A. Next one. Next slide. Okay. So this is what it looks like. The petition, when we go back to the law, this is what it would look like when you talk about the packet. I believe the Washington County and their response to you, they strictly talk about the packet. However, in my appeal to Washington County, I actually appealed both when they denied both. And so I asked for the packet, but I'm more interested in the next slide. Is the signature list. And this is what a signature list looks like. This is what the Norton signature list looks like that I received from the Lieutenant Governor's office. And you see all the identifying information that it had there. And so that's what I'm before you today asking for you to have, I'm going to question, next slide, the classification that Washington County gives. So basically, let me go real fast here. This is just saying that when you do the signatures, they have to be in 2 weeks before the convention. I'm going to go fast. I'm running out of time. So by February 20th, the Governor Cox knew that he has 28,000. And go next slide. So here's an interesting calendar that I want to point out. And this is what my witness is here for. But she's not going to talk because I don't want her eating up my time unless you have questions for her. But what she has an affidavit in here. But what she's going to what she would testify to is that on April 11th, and this is, you see the convention was on the 27th. So, and then that picture I just showed you, Governor Cox declared that he had his signatures by then. Well, on April 11th, my witness was at a meeting in the executive committee meeting of the Washington County GOP. And the clerk told everybody in that meeting that an investigation was going into because there were questions that he had about the signatures that they had received from Senator Ibsen's list that were turned in already. And so go to the next slide. So the reason that that's significant is because you see here that when I started doing a grammar request for the Ibsen list, I start in May and then you know, they on the 17th, they tell me, yeah, you can come view the list. The clerk does. And then on the 23rd, the attorney says, no, you're not going to view it because there's an investigation going. And I believe that then they say in their response to it that they initiated an investigation into the list. You have affidavits, I believe, from from an attorney and investigator, they're claiming they initiated the investigation a day after. They denied me my grammar question, which to me in itself is suspicious enough. But now we have evidence that they initiated investigation way before what they're telling you. Next slide. And so this is just my appeals that went through. And the last point that I'll make with the time I have remaining is that on June 10th, I received, I think I have, so let's go to go to the next slide. I think I have copies of it. Next one. That's Karen's, testimony, and she's available for questions. Next one. And then this is just an article that came out June 21st where, county attorney is calling, saying in the paper that what he's telling us is an investigation. He's telling, the newspaper that it's irregularities, which in my opinion is a little less than something illegal. Next one. And then this is next slide. We can skip that. So this is let's skip those. I talked about those. Next one. Next one. Okay, that's my appeal that I sent in. Next one. And this is the last point I want to make, and I can do this in 20 seconds. So I get this, the next slide, next one. So I just want to point out that when I did my appeal to them, this is the chief administrative officer responds. He doesn't, I did two appeals on the same issue. One is for the package, one is for the list. When they respond, he doesn't even address anything that I brought up in my appeal about the investigation, about how I don't believe that it's a valid classification. And then, so this is the letter he sent me. And he doesn't even talk about anything that I said. So basically I didn't get a response either from the CA. Next slide. We get this email last week. Next slide. And this is what I'll close on, is they changed the letter. They're saying that the letter that was received. So anyways, what I'm saying is the CAO letter, the chief administrative officer letter, this is a different version of it. I never received it. I sent an email right away. I said, look, you got two different versions of the same letter signed by the same person, issued on the same day. Which one is correct? And they didn't respond. But I'm just saying this is a lie. They never responded to any of my concerns in my appeal. And this is very concerning to me that here we are talking about irregularities in election.
Any questions for them?
Mr. Clara, can you give us a little bit more information about the difference between the list and the voter packet?
Can we go back to the first page, to the front, to the first of the PowerPoint?
Yes.
Oh, I'm telling you, but they're doing it. That's good.
Yeah, they're the best.
So, and this is the hard copies that you guys received, because I think that, okay, go back, go forward. So see, here's the law that said, and by the way, this I think took effect May 1st. And it says, and I kind of highlight it because I didn't know any of this until I started doing it. It says that the custodian will provide a list of names and then permit the individual to view. In this case, Washington County said you can view, but they weren't going to give me a list, and I appealed it. And then I ended up appealing the view because they took that away. So next page, to answer your question, this is an example of what the packet would look like. That somebody's out on the street getting signatures, they turn these in, and that's what it looks like. So for me, I'm not really interested in it as much as I am on the next one, next slide. Because the other 2 points I should make is that I'm asking you guys to do the weighing provision, see if the classification is accurate. If you believe it is, then to weigh releasing this Ipsen list because we want to compare it. Well, you guys too could compare it to Governor Cox's list if you went into cameras. But that's the difference.
The packet information is transcribed by somebody to make that list.
My understanding is, yes, that the clerks, the clerks, this is the Norton list that I got from the Lieutenant Governor's office, but Davis County did it because it's a multi-county election, and they were tasked with, Davis County was, so correct. They take all that information and they put it on here. And what makes this relevant is that there's a classification there that says, it says I don't see, the status of the status of action. This one is calling it action. That tells you if the signature is valid or invalid part, if it was knocked out. And that's, I think, what people are interested in, just verifying first of what happened to all the signatures with their classifications. And for me, the list is sufficient.
So Mr. Clara, on the Norton list, just my information, was any of it redacted? Any of the private information, like the registry noted that they didn't want their information released? Was any of that redacted?
And I believe that she's going to address that, but yeah, so you see the column that says privacy. I put these in alphabetical order, and I have them here if you wanted to look at the whole list. I have it on ESP. So I put these in alphabetical order, but what that says is privacy. All those are public. If you were to go down, you would see the names are missing, but I think in this case, they allowed like for the precinct and some other, like the city and the county of the person, but the names are missing, which I'm okay with that and I think by law, as a citizen, I wouldn't be entitled to that either, as opposed to a candidate who is.
Any other questions? I do have one. What, you say the letters were different? Different in what way?
Well, the second letter, the first letter, so let me just say this again. When I do my grammar request, and then I appeal to the first appeal I do, because they said you can come view it, but we're not giving you a list. So I appealed that to the chief administrator officer saying, no, I want to see the list. But then when I emailed them and said, hey, I'm going to take you up on your offer to go look at the packet, which that was all they were offering. Then they said, you're not going to do that now either. And so then I appealed that. So the first appeal, they never replied to. The second appeal, which was a week later, they replied, and it had nothing to do with what my 8-page appeal was. So then last week, when they gave you the letter that supposedly I received, it does respond to things in my appeal. And I think actually it gives a whole different classification, saying, well, we're not giving you the records because it's attorney-client privilege. It's like, first of all, I never saw that. That's a whole new thing. So I just think it's, I think there's a credibility issue on why, and they didn't respond. I said, can you clear this up? Maybe they'll clear it up. No, it's in here.
Okay. Any other, are we fine? All right, let's go to the intervening.
Okay, thank you, SRC. I am here representing the campaign of Phil Lyman and myself. We intervened in this case because Utah law grants transparency in our election process, and this has not occurred. We request copies of the full list of names of those signatures and to view the actual signatures of the political petitions submitted by Don Ibsen and Spencer Cox. We have the right to verify legitimacy of a candidate, and the Lieutenant Governor's office is authorized to provide a list upon request and to view of the signatures. This is the only way to verify the validity and qualifications of each and every respective voter's name and signature. The State of Utah 2024 Candidate Manual, issued by the current Lieutenant Governor, ambiguously references that unknown election officials will review the signatures gathered. Never in this process is there a notice period where opposing candidates, neutral election groups, or everyday citizens are alerted as to when and where the signature packets will be opened, so the public may observe this vital process. None of the campaigns that I have spoken to, ours included, were notified as to when the packets would be opened and reviewed. The accounting, verification, and certification of these signatures occurs entirely behind locked and closed doors. The public is losing faith in our election system due to this lack of transparency. If a candidate gets access to the primary ballot by collecting signatures, the public is to be provided a list of names and addresses upon request and permitted to view the actual signatures in accordance with use in the code 20A 305.3. And they should be able to see which signatures were collected and verify that the signatures were properly evaluated. The public is entitled to transparency in their elections. Article 4 of the Utah State Constitution takes great effort to define the importance of distinguishing what entails a qualified voter. Without transparency in the election, the closed doors will continue on into future elections here in Utah. Today, you must decide 4 glaring issues. Number 1, whether the public's interest in transparency outweighs the Washington County's attorney that this information remains withheld. Number 2, Although we contend that only the signature is classified as protected under 28.305.4. Whether you will abide by this guidance under 28-2-104 or 28-2-108, which explicitly state that as a candidate, I am entitled to all voter data, including classified, private, and withheld voter registrations. Even the voter register. So when you go to vote and you mark the voter registration, you mark you want to be private. It says that this information will be available to candidates. So, and it says that the only information that as a candidate I'm not entitled to is a driver's license, ID number, social security number, email address, and phone number. So number 3 thing to decide is we need to reconcile why the private voter information is provided to the other candidates and their signature gathering companies so they could gather those names, but this access is denied to us as convention winners and convention candidates. Number 4, we need to reconcile why entities outside of Utah, such as NGOs and the ERIC system, are provided with this private withheld confidential voter data, but this information is being denied to other candidates and to Utah citizens. So as background, there's 2 paths to get onto the ballot. There's a caucus convention path and the signature gathering. We went through the caucus convention path. Delegates to state convention are unpaid, whereas the campaigns who pay the people to collect signatures essentially buy their way onto the ballot. And when nominations are tallied at the convention, all stakeholders are present to oversee the process as winners are determined. In the signature gathering route, not even the campaigns are permitted to be on site to view this accounting process. We're closed out of all this. It happens entirely behind locked doors. And even after the primary, the denial to review these signatures is ongoing. Signers are not even notified if their signature is disqualified. So there's a serious question here about whether enough signatures were actually gathered by all of our, because all of our grammar requests to be provided a full list of the names and addresses and to be able to view these full lists of signatures have been denied. Every grammar request has been denied for us. The public has the right and must be able to verify for themselves whether valid and qualified signatures were actually gathered. Under GRAMA, the State Records Committee must determine if this information is protected. And if it does the public's interest in disclosure outweigh restricting access? The legislative intent for the GRAMA Act is to promote the public's right of easy and reasonable access to unrestricted public records, to provide favor, and they should favor public access if there's a countervailing interest are of equal weight. The GRAMA request should be fulfilled by providing this information that government agencies are capable of providing without delay by overly precise wording or technicalities. The data was not gathered by a government entity, but by a company hired by a political candidate, which gives even more reason for the public to have access of it to be able to verify it. The Washington County himself already voluntarily made public that there's a criminal investigation. The following are the list of the reasons why the names, addresses, year of birth, and voter ID should be disclosed to us, as well as being able to view the signature packets. Number 1, it's my constitutional right to access this information concerning the conduct of the public's business under 63G, which you referred to. Number 2, there are conflicts of interest. For example, Lieutenant Governor refused to recuse herself from overseeing this election. Number 3, because Ipsen and Cox use the same company, there's likely overlaps in signatures. The Utah signature gathering process has no external or internal controls that are transparent to the public. And as you can see, looking around and online, there are many, many people here today that are interested in transparency, and that's critical to our election system. We believe here that the interests favor disclosing the list to the public in full with no redactions. Thank you.
Okay. Ken, you have a question.
Clawson, can you give us a little bit more information in your list of 4 items? Can you address again or clarify number 3 and 4?
Yes. So why private voter information is provided to candidates and their signature gathering companies. When we look at the list with the redactions, about 40% of them are private withheld names. So the signature gathering companies, when they go to knock on doors, they're given a full list of people that they should contact to register voting, whether they're private or not private. So they go to those homes of people and they're able to get those names and they sign them, and then they go on to the nominating petition. But then we haven't been able to have access to that. our intention is that we really, this information where you mark that you're private, it's only for the voter registration. It's not for putting the name on the nominee. So that's just a separate question. And even if it was, we still should have access. And even, I mean, there's several low, even if so, if you mark that you want to be private, you go to the voter thing, you mark you want to be private. It says my information will only be available to my candidates and their contractors. So in this case, their contractors have not, but the opposing candidate does not have access to their. So that's our concern. That one. Second one, we mentioned that it is available. So this transparency is not available to us where we feel like we have an added interest and the public, but it is available to you. My point on there was NGOs and like Eric is our electronic records system. That's a multi-state system. That is given access where it's being closed out. We're so close to the election, but we're the election.
On that, the sharing of data. NGOs, Eric,
Yeah.
are they sharing that data for statistical reasons, not for the specifics about the individual, broader,
Right.
or statistical reasons, or studying?
Yeah. Yeah. So that is part of it, but there's questions about the voter rolls too, and being able to clean up the voter rolls where people, I mean, this is kind of a different conversation, but we believe that there is an interest that these voter rolls are being public, so that would be public, not just available to certain contracted groups.
Thank you.
Ms. Clawson, you said you had several denials of your grandma requests. Were they for the same reasons that Mr. Clara's were denied?
Our request was to be able to vote, to view it in full. We feel like that it doesn't do us any, it's having a partial list is not what we're looking for, because our question really is, were there enough signatures? Ultimately, were there enough signatures to get on the ballot? And there's only, I mean, it's in the governor's race, he only turned in an extra 592 signatures, and you can't verify. You shouldn't be able to verify it past this point, and those weren't verified. So there is a legitimate question of being able to see the entire list without the withheld and redacted, because right now when we do our grammar request, it shows great lines and it says private, and it just gives the county where we should have access to the names and the addresses for each of those individuals. They should be a data holder instead of blank. It's just essentially 40% of blank lines.
Thank you.
I'm sorry, and so we asked to have a copy and we asked to view, and we were also denied the opportunity to view them without being redacted. They said they would have to go through the process and redact all of those before we view it. And the soonest we could see it was the end of July. And we were asking, and as Michael mentioned, we were alerted to this early in May, and we were taking the steps necessary before the primary. Most of this was done before primary, where we did all the grammar requests before. So we were acting as quickly as we could in the process. I mean, it's taken long. Oh, there's a lot of steps to get to this point, but we were denied.
The other questions from the committee? Okay, then we'll move along to the respondent, Mr. Clark.